Namaste. So two more sections related to arrest, very tiny minor sections, and then we move on to the accused coming to the court and how do we get them. Section 51 से आप अपनी sections वाली list में note down कर लीजिए. Now this is search of arrested person. So when you pick up this section from the Bare Act, have a cursory look on it. You will notice that it has a lot of provision which is again and again mentioning bail. So whenever it says that the person is arrested under a warrant which does not provide for bail, or if bail is provided, the person cannot furnish for such bail, and there are two more conditions to it. We need not discuss it because this section I'll discuss when I get to bail. This section is not applicable, but otherwise, for example, let us say that you are arrested, right? You are arrested, and you have your let's say watch with you. You have your, let's say, a phone, consider this as a phone. You have more accessories, you have your belt, you have everything with you. So that can't be committed, that can't be taken to jail. For example, the watch, the phone, anything cannot be taken to jail. इसलिए अब law का core funda is that it has to be written somewhere. So how can a police person, or rather police officer, oh sorry, I'm saying police person, police officer search you? Because it's written section 51 के अंदर. And think about it that, why is this bail being exempted? मतलब, if the warrant provides for bail, or if let's say bail is available, then they need not search you. Why? You remember bail is a matter of right. So when you anyway have to get bail in that offense, obviously it has to be a bailable offense. Why will the police guys search you, remove all of your articles, keep them in a safe locker room, and why will they take you in? They'll just have to give you bail. It is a matter of right. Remember? So this is how, and I need you to get curious about these situations. Ask the question why in your mind. Why is this written like this? मेरे लिए पढ़ाना बड़ा आसान है, to tell you very honestly. I mean, these are like the simplest sections to teach. But you, on your own, need to think that why is this written? Why has the lawmaker written this? Because it's a matter of right. So if it's a matter of right, why do you need to remove my phone, my watch, my, let us say, microphone, my remote, whatever it is? Why do you want to remove it? So therefore just give me bail. So herein, search of arrested person, जहाँ पे bail नहीं है, obviously फिर हम आपको jail में डालना, we have to get you to jail. So we'll remove everything except for wearable apparel, that is your clothing, and then commit you to jail. Alright? So search and place in safe custody all the things that we find on you. Let us say that a person has a knife or a gun, and then we take you to jail, and then without searching you just put in there. You're going to start murdering people, or somebody will get hold of those weapons and murder you. Right? So we need to search you before we commit you to custody rather. And then if it's a woman, then search will be done by a woman police officer only, of course. I mean, so CRPC में woman to woman. It's as simple as that. All right. As soon as women come, you need women police officers. That is why we have women police officers mostly in a very prominent number now, because the provisions require so. All right. Now there's section 60A. It's A. That means it came via an amendment. Which amendment? Mostly it is 2009 amendment when it comes to the arrest provisions. Okay, so now it says 60A says that no arrest shall be made except for the provision in this code. I'll just read out the exact title of the section for you so that we are on the same page. Right, here it is, 60A. Arrest to be made strictly according to the code. No arrest shall be made except in accordance with the provisions of this code or any other law for the time being in force providing for arrest. अब किसी और law के अंदर आप arrest हो सकते हैं, तो वहाँ पे जो arrest की जो provisions दी हुई हैं वो आप follow करेंगे. अगर आप CRPC के तहत arrest कर रहे हैं तो आप यहाँ पे ये follow करेंगे. Now another thing is, when we come to layer 2, I'll have to answer this for you. Start thinking, what is this code? Why is this not an act? So there's a difference between a code, a statute, and an act. Think about it. चलिए statute वाट्यूट छोड़िए. Code and an act. Let us say हमारे पास Right to Information Act है. Why isn't it the Right to Information Code? So it is the Criminal Procedure Code. It is the Indian Penal Code, right? We're talking about codes here. We'll get to it. Just getting your brain started and warmed up. for what lies ahead. Now section 60A के अंदर अगर आपने काम नहीं करा and you note this down, this is like prelims की गंगा यहाँ से बहती है. 60A के तहत अगर आपने अरेस्ट नहीं किया तो आपके साथ क्या हो सकता है? एक तो departmental inquiry will be there if you are a police officer, that is for sure. Well, let us say the other guy, what is the tort that is similarly related but not exactly related to this topic? The tort is malicious prosecution. Similar related, not entirely related to the topic, similar funda, but we'll get to that later. But in fact, this course is not about torts any which way. So 220 IPC, I implore you, pick up the Bare Act, go to 220 IPC and read it once. What happens when you have the authority to arrest but you use that authority illegally? How is it an offense and it's defined there in 220 IPC? Have to remember this section because it's related here. Okay, 342 के अंदर आपको wrongful confinement में भी आपके ऊपर केस चलाया जा सकता है because you have wrongfully confined, and there is a difference between wrongful confinement and wrongful restraint, right? Different funde under IPC. If you studied the IPC very thoroughly, you'll know what I'm talking about. And then the other person, the guy who got illegally arrested, can also file a civil suit and then basically sue you for damages, right? But the most important thing that you're going to remember is that the trial will not be void just because the arrest provisions were not satisfied or were not met. So the lawyer that is there as a defense pleading, में जो वकील साहब हैं, he cannot take up the defense that, you know, since my client was arrested illegally, he cannot be tried. Trial चलेगा, by the way. This not following the arrest का काम अलग शिकायत दर्ज होगी, अलग केस जाएगा. हम CRPC के तहत there is no bar to the trial. Hopefully you're getting it. आपका ट्रायल होके रहेगा provided that कि once you've been arrested, you know, the offense, everything is established, the police has a case against you. So the first thing your defense lawyer may just pick up that my client was not arrested in accordance with the provisions of this code. So the judge sahab will say, well, then you go, this is a separate remedy available, and then the judge sahab will also look into it, but judge sahab will not cancel the trial. It cannot be vitiated because the provisions of arrest were not followed. Just remember this for now, okay? 51 and 60A. So now pretty much we have discussed the most important introductory concepts of arrest, and now let us try to get the accused to the court. अभी तक हम कहाँ पहुँचे थे? अभी तक हमने पहले ये देखा कि ऑफेंस किस टाइप के हैं, फिर हमने देखा जज साहब कहाँ पे हैं, फिर हमने देखा कि जी पुलिस वाले क्या करेंगे, अरेस्ट कैसे होगा, नहीं होगा, किस केस में होगा. Now we are here, now we finally done pretty much with the introductory concepts of arrest, and then now we're going to get it to now enter into the waters of the court. ठीक है जी, see you in the next one. Take care, bye.